Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, you shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is in re amendments to the Florida Rules of Juvenile Procedure. Counsel?
Good morning. My name's Kara Fenlon, and I'm here with my colleague David Silverstein, who is the current board of the Juvenile Rules Committee. We're here on behalf of the Juvenile Rules Committee to address a couple of our proposed amendments. I'm going to be addressing the proposal to amend 8.80 C10 and the proposal to amend 8.090 M3. With your Honor's permission, may I start with 8.090 M3? This is a rule that's regarding recapture period for a speedy trial after a motion for dismissal has been filed. This issue came to our attention about reviewing this rule when the court made its finding in State v. SA. The committee discussed this issue, and agreed with Justice Pariente's concurring opinion, where she pointed out that the original intent of the rule that was in the committee notes in the Criminal Rules Committee was that it be a single 15-day period. We decided that is our intent as well, and we went ahead and amended the language to the proposed amendment to...
Is it correct that the Criminal Rules Committee did not propose that change in their cycle?
No, they did not. As far as we know, they didn't get out of a subcommittee on that, but we are a different committee.
Those rules have always been identical, right, in the Criminal Rules Committee and Juvenile Rules?
Yes, Your Honor, I believe that rule has been, but there's many rules that vary. We don't, we diverge a lot, and especially in areas where time periods are an issue. As Your Honors know, juvenile court is very different than intent than adult court. It's rehabilitation, and one of the issues that we try to address are to address things in a very timely manner. Majority of our cases, or a great percentage of them, go from charge to completion in 21 days. So 15 days is for a recapture period is quite a good amount of time in comparison with juvenile court.
Is the criminal committee considering this kind of change also?
We couldn't get a clear answer on that. We know it didn't,
Did you attempt to coordinate with them?
Well, we attempted to see whether they were going to address State v. SA. For us, it seemed we were intrigued and we believed that it was an important opinion. Our impression is that they did not take it as quite as seriously, and that it didn't get out of subcommittee with them. Now, Your Honor, we believe that our proposed amendment is clearer. It goes to our original intent, and we would ask Your Honors to agree with that amendment. Any more discussion on that, or would you like me to address 8 point? Okay.
Just proceed with your argument.
Okay. Your Honor, so for now, if I could address 8.080 C10, and that's the amendment where we would like to add in the plea advisement a warning regarding immigration consequences.
Well, let me ask you this. It has said deportation before, the deportation consequences, and so What are we adding by using the word immigration as opposed to deportation? I mean, it seems to me that you are broadening. Are you attempting to broaden the scope of what must be told?
We believe, and this gets to the Honorable Blaise Tredis's comments, we disagree with him. We believe that there already is a broader mandate in Padilla to give a warning, even if it's a general warning, about immigration consequences that are broader than deportation. We believe that children in particular are vulnerable. They need more protection. We can maybe expect an adult to have contemplated the possible consequences of the plea in light of their legal status, but we can't expect that a juvenile is going to contemplate that. And at the very minimum, we ask that they be given a warning that what they do today could have consequences. And in Padilla at 1483, there is that duty that is spelled out, that when it's not as clear cut what the outcome could be, but there could be a potential issue, that warning is a duty of the attorney to give to their non-citizen client.
Is the criminal defense lawyers on your committee or feel that this is assist them in advising their client? Because that's, to me, it's really, since we know what's going on in this country right now with all sorts of issues that may not have been contemplated, is it correct that the actual adjudication of delinquency does not itself give rise to deportation, but it's the acts underlying it that would, and that's what...
Absolutely, Your Honor.
But what's the view from both the prosecutors that are on your committee and the criminal defense lawyers?
We were in agreement that this is already a duty, that this kind of a general warning should be given already, and that is part of case law, and that we're not actually broadening anything. We're just making sure that the most vulnerable group and the most vulnerable court that we have gets that information. Yes, they don't, a juvenile plea is not considered a conviction that can lead directly to deportation, but they can use the acts within that plea to potentially deport somebody or to deny them paths to citizenship, green cards. And a lot of children, as opposed to adults, and their families believe that what happens in juvenile court stays in juvenile court and will have no impact on their adult life, and unfortunately that is not the case. And while they might be contemplating the number of community service hours in the plea deal, they may be actually setting themselves up for a much more difficult situation. And we just want them to at least have heard that potential, and if that is a concern of theirs, then we can assist them in trying to get some more information.
So I'm having a little, so this kind of warning is given to every juvenile or just juveniles who are not citizens of the United States?
It would be given to every juvenile.
Because later on it says something in the rule about not disclosing the legal status of the person. So every juvenile would be given this warning.
That is correct. And now, when I'm talking about the defense attorney may know a little bit more information and broach the subject a little bit more deeply with a client they understand to be a non-citizen, but that is not something that would be in front of the court, and the court would give that warning and would not inquire regarding the child's citizenship. So, Your Honor, so again, the courts have been moving more and more to recognize that children are different. Children need more direction. They need more protection. And I believe that child defendants need to know that there could be implications that are very serious, that go beyond what is on the four corners of that plea form. And
Are you going to be talking about the testimony being taken, or that's?
my colleague's going
Okay, all
to be talking about that. So-
Let me ask, what was the vote on this?
I
at the
believe
committee?
this vote was unanimous,
Unanimous?
yes.
How about for the first one, that we were discussing?
I would have to look it up, but I don't think that was, I think it was a large majority to it, but not unanimous. All right, thank you, Your Honors.
Thank you.
May it please the Court. Good morning. My name is David Silverstein. I'm the current chair of the Juvenile Court Rules Committee. I'm going to speak to you regarding our proposed Rule 8.255E regarding testimony by communication equipment. The Court specifically asked me to come here today to answer several questions. One is whether our proposed rule regarding testimony by communication equipment is consistent with existing Florida Rule of Juvenile Administration 2.530, and whether our proposal should be coordinated with the amendments that are currently being made to Rule 2.530 and the Florida Rules of Civil Procedure currently being developed. As far as our position, we believe that our proposal is consistent with 2.530, and specifically Rule 2.530 sub D sub 1. We believe that provision allowed all the procedural rules committees to create their own rules regarding testimony by communication equipment. D1 specifically says, it says generally, a county or circuit court judge, general magistrate, special magistrate, or hearing officer may allow testimony to be taken through communication equipment if all parties consent or if permitted by another applicable rule of procedure. Now, when amendments to Rule 2.530 were considered by this court in 2011, this court specifically added the phrase, if permitted by another applicable rule of procedure, to Rule 2.530. So,
Well, is this 8.255E, is that both a rule for juvenile delinquency and juvenile dependency?
it is only dependency.
Okay, so we should clarify that. So this is not, so there's no rule in juvenile delinquency procedure, just like there wouldn't be for criminal for this kind of testimony?
Now, the Juvenile Courts Rules Committee did consider a similar rule for delinquency, and that is on its way to Your Honors.
Well, shouldn't we, in trying to decide what the value is, maybe you could explain it. What is the goal of this in a dependency proceeding where it's really unlikely that you're going to have witnesses that from afar, and the idea of the judge eyeballing those that are going to either decide where the judge has to either terminate the rights or allow the parents to be reunited. What type of witness would it be that would be covered by this?
Thank you, Your Honor. As you know, in dependency court, time is of the essence. We have many, many hearings in the life of a case, and the judge, as a trier of fact, needs as much information as possible to make critical decisions regarding the family. So we designed our rule to accommodate this. You're in court. You're at a shelter hearing. You have a case that you're considering where a baby has a leg fracture. The child protection team doctor has given an opinion to the child protective investigator that the doctor believes that it's from abuse. the parents show with their attorney. Their attorney wants to cross-examine or ask questions to the doctor. The doctor is in the hospital doing rounds. They're running around. They don't have access to a notary, and the judge wants to get the doctor on the phone. So the alternative is to continue the hearing until we can arrange for the doctor to be present when a notary or come in court.
And when you say
that
we,
delays.
who do you represent? What's your?
I am a managing attorney with the Department of Children and Families.
Okay.
However, in the scenario I'm explaining, the parents want to talk to the doctor. They want to question the doctor. The judge wants to question the doctor. So we don't want to create delays, and we want the judge to have the ability, say, if the child protection team doctor has testified before this judge 20 times in the past, that the judge can get the doctor on the phone and recognize the doctor and take the doctor's testimony. There's also situations where we may be in a hearing where the judge wants to know, the issue may be, did the parent show for their drug screen? The person from drug court that does the screens is not available. So the judge everyone wants to know, what's the answer? Did the parent test positive? Or please explain the results of the screen. And we can't get a resolution. Maybe the situation is that we need this result so that the child can be reunified.
Can I ask a question? Did everybody on your committee agree with this? Because you representing the department, judges may want it to be, to expedite, and that's a good thing. But what about the attorneys for the children? Are they in favor of this also?
Yes. Our members of the Juvenile Court Rules Committee, we have judges, general magistrates, attorneys who represent DCF, parents' attorneys. We have children's attorneys, guardian ad litem attorneys.
I just want to know, because it's the children's, here is the thing that always concerns me, is we do want to expedite this, but as you know, because since you're familiar with baby court, that there is a way that you do things where what you're trying to do is create an atmosphere where you can reunite the family or terminate the rights. I just don't want this rule to be turned into somehow we're going to have decisions by remote, telephone or video. And so how is this understood just by saying good cause, that that's enough to assure the court, the judges, that it won't be a shortcut?
Yes. Well, it is good cause.
But good cause, to me, frankly, I've seen it with other rules, it's so amorphous about what good cause is. You're saying what you're describing is kind of an emergency, that this is, the child is in danger, we need, so how do we define good cause in any more detail?
Yes, we do define good cause. We have our committee note where we explained about good cause. A party seeking to present such testimony over an objection must satisfy the good cause standard. In determining whether good cause exists, the trial court may consider such factors as the type and stage of the proceeding, the presence or absence of constitutionally protected rights, general substance of the testimony, the importance of the testimony to the resolution of the case, the cost or inconvenience of requiring the presence of the witness in court, the ability of counsel to use necessary exhibits or demonstrable aids, the limitations, if any, placed on the opportunity for opposing counsel and the finder of fact to observe the witness's demeanor, the potential for unfair surprise, the witness's affiliation with one or more parties, and any other factors the court deems material to weighing the justification of the requested party.
This is what I don't quite understand. So you want a rule that's different from the rule of judicial administration and the civil rules, that would essentially waive some protections for parties by having a notary there, that kind of thing. And your justification is that everybody in the courtroom will want this witness, want to be able to question this witness, or want the judge to talk to this witness. And under the rules, if all parties consent, you can waive any requirement that's designed to protect that person, the party. So I don't understand why it's a problem, because in the situations you're describing where everybody wants for expediency's sake, the judge to be able to talk to the doctor right now rather than delay this, they don't have to wait for a notary. If everybody waives it, they can talk to the doctor, they can take testimony, right?
Yes.
So why do we need to make a different rule to account for a situation that is handled under the current rules?
Your Honor, thanks for bringing that up. Our rules, specifically as far as allowing the judge to swear to witness remotely, only pertains when all parties agree and there's no question as to the identity of the witness.
And that's an important protection, right? I mean,
right.
Okay.
But I have been in situations where, because there has been no rule regarding this, or you default to the rules of judicial administration, that the judge will not, even though the parties agree, the judge will not get someone on the phone because there is no notary present. So it does cause delays.
but you would agree that if all parties waive that requirement because they know the witness and they're not concerned, that the judge could do that, and that would not...
Yes, but what I'm saying is that the reason why we wanted to put it specifically in the rule to advise the judges, the dependency court judges, that they do have this option.
But wouldn't the rule allow it even where all parties don't agree?
Not as far as the notary. The waiver of the notary to be physically present with the witness, to swear the witness in, that only applies when everyone agrees, and there's no question as to the identity of the witness.
Mr. Silverstein,
Okay.
go ahead.
No, I do. You have, I'm also, since I'm always concerned about the rights of children who are at the center of this, I noticed that you say it doesn't apply for parents at certain proceedings, but we have rules about when children should be there, and that's part of what the whole change in ensuring that children have a voice. So why isn't that, why don't we reference those rules that already require children to be present?
It's as far as, Your Honor,
Well, are you
asking-
anticipating that something happens, you can just take, telephone a child, and instead of the child being present, just talk to them over the phone?
Well, if it would allow that situation to occur, say that the child is in a locked facility several hundred miles away, and we wouldn't be able to get the child there for a status conference.
Well, would you use video? You would swear the child in, you'd make sure the child, if they're in a lockdown, I'm sure they have an attorney. I mean, you wouldn't have to worry about some emergency. Here I'm understanding you're talking about something that's an emergency.
Well,
And it feels like the scope could be far larger, and you are in your rebuttal. So you're saying that children wouldn't have to be present, but right now, if they were in a facility hundreds of miles away, I'm sure there is procedures for using video equipment if you need their quote testimony for their, what their future is going to be.
yes, Your Honor. And Your Honor, I did want to differentiate. Our rule deals with testimony, not appearance. Thank you.
Mr. Silverstein, you have consumed most of your rebuttal time. I will nonetheless afford you 3 minutes.
Thank you very much, Your Honor.
Good morning, Your Honors. My name is Miguel Tremor. I'm here on behalf of the Civil Procedure Rules Committee of the Florida Bar. I've been called to address the last two questions that Mr. Silverstein has addressed. By way of background, it's just as a matter of coincidence that the Civil Procedure Rules Committee and the Rules of Judicial Administration Committee have been jointly working on some proposed rule changes that are covered by Juvenile Court Rules Committee's changes to 8.255. And it addresses those rule changes, which have been unanimously approved by the two committees, save for a couple of abstentions. They address telecommunications equipment for the purposes of taking testimony. There's two broad distinctions that we draw. One has to do with audio communications equipment, and the other is audio-visual communications equipment. When audio-visual communications equipment is used, our proposed rule changes would allow the parties to dispense with the physical presence requirement of the officer who swears in the witness. Why with audio-visual but not with audio only? Because with audio-visual communications equipment, the officer who swears in the witness can confirm the identity of the witness. Now, one of the major substantive differences between the joint proposals of Civil Procedure Rules Committee and Rules of Judicial Administration Committee on the one hand, and the Juvenile Court Rules Committee on the other hand, is that the Juvenile Court Rules Committee's proposal would dispense with the requirement of the physical presence of the officer if the parties agree to it. We believe that that is inconsistent with Rule of Judicial Administration 2.530D as it's presently written, because while 2.530D1 talks about the use of the communications equipment, 2.53D3 talks about the requirement of an oath. And that rule presently states that the oath must be physically given, must be given in the physical presence of the witness by an officer who is legally authorized to do so. That is precisely what Civil Procedure Rules Committee and the Rules of Judicial Administration Committee are addressing, but only in the context of communications equipment where the witness can be seen by everybody. Now, the other question we've been called to address is whether the proposed changes by the Juvenile Court Rules Committee should be coordinated with the proposed amendments to Rules 1.310 and 1.451 of the Rules of Civil Procedure and 2.530 of the Rules of Judicial Administration. Our position is yes, they should be coordinated. This is a matter as to which there should be uniformity. Take a look at the Evidence Code. Section 605 of the Evidence Code, which is of general applicability, requires each witness to be sworn in. By the same token, the rules of court, regardless of the litigation context, they should be uniform on the issue of when the officer who swears in the witness has to be physically present with the witness. Now, the Civil Procedure Rules Committee commends the Juvenile Court Rules Committee for their efforts to craft rules that will facilitate and expedite their jobs. We're also aware of the unique challenges that practitioners face under Chapter 39 of the Florida statutes, but we nevertheless believe that this is a matter where the law, the procedural law, and the substantive law should be uniform. The issue of an oath should remain constant, regardless of whether you're practicing in the civil litigation context or dissolution of marriage context or dependency context.
The only thing I would say about that, the values, like if you take a civil case, right, personal injury, a commercial case, you've got normally two lawyers and, you know, you might have high stakes. So the decisions, I mean, it's not going to be this situation as was described for dependency where something's an emergency. You've got to, you've got to get this testimony of the doctor who saw the baby, as an example. So if we defer it so that everybody can get together, would you agree there might be some differences, dissolution of marriage, dependency, because again, in dissolution of marriage, we have many cases where they're unrepresented versus other civil cases. Have you taken that into consideration in looking at the protections we need to afford the litigants and, the constitutional requirements?
Right, we have, Your Honor. We feel, the Civil Procedure Rules Committee feels that when you're taking testimony through audiovisual means, that there is a degree of solemnity involved, and there's also the ability to have the parties confirm the identity of the witness. If you're visually seeing the witness who's about to give testimony, you can ask for photographic ID in that sense, but that capability is absent where you're taking testimony through purely auditive communications equipment.
Can I ask on this, because telephone to me is the least satisfying of trying to get a sense. As you look at this, again, we always think there's got to be a court reporter or something there, but with all of this, whether it's FaceTime or, the things that everybody seems to use where you can see somebody, does that count as audio-visual? If there was a witness there, a notary to swear in the witness?
It would count, Your Honor, but the rule changes, the rule proposals rather, would condition that upon the agreement of the parties. So FaceTime may be an extreme example, but a typical televised deposition or a televised testimony may be more suitable.
But that requires, for those, it would require a video operator to be actual videotaping the testimony so it's preserved?
Yes, absolutely.
Thank you.
Thank you, Your Honors.
In responding to Mr. Chamorro, the Juvenile Rules Committee firmly believes that Rule 2.530 sub 1D allows for a lack of uniformity so that the rules committees could create a rule for testimony by communication equipment which meets the needs of their specific practice areas.
I don't have a problem with that, but what's wrong with deferring this and letting there be, the committee, your committee, meeting with the Rules of Judicial Administration and the civil procedure to make sure, that everyone's thought of all the possibilities. You've got judges on those committees that may have, had other experiences. I just don't see sort of the downside of having that done, and they may say then, and with the approval, that yes, this would be a difference in this very narrow circumstance, because that's what I wanted to be, a narrow circumstance, not become the rule. I'm just very uncomfortable with testimony by remote. I just don't think it ever captures the real, the essence of what you get in face-to-face communication, no matter what we have, progressed to.
Yes.
So what's wrong with that?
Your Honor, there's absolutely nothing wrong with that. In fact, what I did on June 15th is I went to the meeting of the Rules of Judicial Administration Committee, and I raised this issue with them, whether they believed that this provision that says, if permitted by another applicable rule procedure, allows the Juvenile Rules Committee to create its own rule, and the chair, Judson Cohen, conducted a poll of the members, and pretty much all the members agreed that the Juvenile Rules was free to create their own rule to meet the needs of the litigants in dependency cases. The Juvenile Rules Committee passed this, and this is attorneys from all different sides approved this by 23 in favor, 1 against, and 1 abstention. The Juvenile Rules Committee is willing to work with the Civil Rules Committee. When I received the comment from the Civil Rules Committee, I was in contact with the Civil Rules Committee to try and resolve the issue. The heart of the issue is that which I understand, Civil Rules believes there needs to be uniformity in the rules. The Juvenile Rules Committee does not believe that there needs to be uniformity in the rules. Thank you.
Thank you very much. Thank all of you for your argument. We'll now move to the second case on our docket, the State of Florida versus Peraza.